and welcome. My name is William Malcolm. I'm a lawyer with Pinsent Masons, the law firm behind Outlaw.com, and I specialise in matters concerning the use and disclosure of information. Today we are going to be looking at information security issues, particularly the information security issues that arise when an organisation passes data to a third-party supplier. Now, why is this important? Why have we chosen this topic? Well, simply put, public perceptions have altered radically over the past year, and furthermore, you'll all have been familiar with the spate of high-profile security breaches we've seen in recent times, most notably HMRC losing the details of 25 million recipients of child benefit. This is not just a legal issue, it's an issue about the management and mitigation of identified risk. When you pass information to a supplier or contractor, you ought not to be concerned only with the information you're passing to that contractor from a contractual standpoint, but you should also be concerned with what practically you're doing on the ground to ensure that the data are properly managed. In essence, it's about having the right contract, but it's also about having the right risk and governance processes too. Risks need to be identified, treated where possible, and mitigated and managed where not. The key phrase on security in the Data Protection Act that people need to be aware of is that you must take appropriate organisational and technological measures. What does the Act mean by the phrase appropriate? How does one assess what an appropriate security standard in any given context is? Well, helpfully, the Act sets out a number of factors one can take into account. These are the state of technology in the market, the cost of implementing that technology, the nature of the data itself, and the harm that might result from its disclosure. Effectively, organisations need to take each in turn. Technology trends change over time, so one has to constantly assess and reevaluate the technology that exists and whether or not that technology is appropriate for protecting the particular data. One also has to look at the nature of the data itself. Confidential financial information or medical information will necessarily require a higher standard of protection than more basic business contact information, for example. Then one also has to consider the cost of implementing measures. And again, like state of technology in the marketplace, costs can vary drastically over time. So one constantly has to evaluate whether the costs of implementing a solution are changing and what competitors are doing as market practice evolves. Finally, one has to take into account the harm that would be caused by disclosure of the data. How would that affect the individual? And what would the individual have to do to put their life back on track? It's by looking at all of these four factors together we can arrive at a view of what is appropriate. It's true to say that security practice evolves over time. What is appropriate today may not be appropriate tomorrow. Therefore, it has become increasingly clear that organisations need to keep on top of monitoring whether or not their security plans work for their given data collection at any particular time. In terms of evolving practice, four things are starting to happen. Firstly, organisations are starting to review standard form contracts with suppliers. This is important because organisations will have an opportunity at the start of new relationships to set out properly what information security requirements they expect the organisation to comply with. There's a real opportunity to set out these new standards in any new contracts and to ensure that the wording and language of the contracts reflects current information security policies and requirements of the organisation. Secondly, organisations are starting to review existing high-risk and high-value contracts. Now, we accept that it's not possible to review every contract and to review every relationship, but it should be relatively straightforward to identify particularly high-value contracts or contracts where the disclosure of the information is particularly sensitive, and to look to see whether or not the standards in those contracts and the information security schedules that sit behind them are appropriate for the given context. The next changing aspect of practice is that organisations are starting to develop more bespoke information security plans for outsourcing and supplier scenarios. There's a clear opportunity at the start of new relationships and at the start of new arrangements to make sure that specific information security risks are identified and that plans are responsive to those specific requirements. And lastly, there is a recognition that more internal and external audit is required. Previously, even organisations that were getting it right drafted contracts that tended to live in a drawer, whereas now organisations are starting to recognise that real mitigation and management of information security risk only comes by continuous improvement and by ensuring that a proper audit programme is in place. The final thing to reflect upon in terms of the changing landscape is the place which information security issues now have on the corporate agenda and in the boardroom. Information security has never been more important, and organisations are continuing to take active measures at a senior level to ensure that information security risk is properly mitigated and managed. That applies whether you're in the public sector or whether you're in the private sector, and it is this change, perhaps more than any other, which will help ensure real progress towards the protection of personal information and confidential data.